Meeting will come to order. It's September 8th, 2/12. And it's a special meeting regarding legislation we're going to, which we had started. I can't think of the date offhand, but anyhow, we're going to complete that. Julianne, yes, Julianne, you had sent us an email regarding a question we had on a listing agreement required prior to showing a potential buyer property. Can you hear me?
I can, yes. So would you like me to speak to that question and pose it again to the group?
Okay.
So what I'm hoping to find out from the board members individually is to determine how we move forward with how buyer representation agreements are, because there has been a lot of confusion in the past, and even after the last minute, there was still some, or after the last meeting, there's still some gray area as to specifically, what we write into statute. And again, proposal, as in this proposal, for when a buyer representation agreement needs to be executed. And so the very narrow question I'm hoping to get answered today is a buyer representation agreement required prior to doing a showing? And so I'm hoping that the chairman can do a roll call of the members so that we can get an answer on that.
Okay. The question is that you had, is a listing agreement required prior to showing a potential buyer a property? That was a listing agreement.
It should be a buyer's rep agreement, not a listing agreement. Those are two separate things.
Right.
Yes, the buyer representation agreement.
Okay, the email said listing agreement, so it posed a little confusion.
Oh,
The email you sent us is a listing agreement required prior to showing a potential buyer a property.
I apologize. So it's a buyer representation agreement
Okay.
prior to showing, yes.
Is this a formal motion with a vote?
This is not a formal, we do not need a resolution. This is a kind of, in order for us to have a direction related to policy of the board, what direction we should be going in terms of drafting. I'm just looking to have a better understanding of the individual board members.
So, the concern, so what you're saying is that it's unclear currently in Connecticut if it is required or not. The question is, if we're requiring this, now we've established agency. So must someone, in order to show property, be acting as an agent? That's really what the question is.
So
At least that's how I'm hearing it.
I don't know if the question is as broad as say, are you engaging in the practice of real estate? I think that there's certainly indicators in the law that would be true. I think the question is, are you negotiating to the point where you need to have a buyer representation?
But the question, that's not the question posed. The question posed is, can I show a property without having a buyer's rep agreement? So really
Yes.
The question is, am I their agent? So without that, what we're saying is I can't show property unless I am the agent and the representative. Right now, currently, I have two distinct relationships. I have clients and I have customers. And what this means is there are no customers. I have clients and I have clients.
No, you could have customers if you're the listing agent, because you could show a listing representing the seller, and the buyer could be unrepresented.
Not with what we're talking about. I can't show it. I can't open that door for anyone, no matter who I represent. So I can't show it to anyone who I don't represent. I would be forced to represent both sides the way we're considering writing it.
I don't know that Julianne meant that the way she wrote her. Maybe Julianne can clarify what she's trying to ask.
This is part of the question, is that in order to show a potential buyer of property, if you are going to be a middleman between the buyer and the seller and do a showing, do you need a buyer representation agreement?
I have to represent, I personally feel, I know this, so there's no, what we're arguing right now is there isn't really statute that says what we're supposed to be doing. We're following a policy which may or may not be legally binding, right? So I, as an agent, personally feel that I need to represent somebody when I'm going to a house. So I either represent the seller because it's my listing, or I represent the buyer because they have chosen to work with me, at least for that property, to see that property. If I don't represent anyone, I shouldn't be at that house.
But if, Amy, if it's your company's listing, you are representing as an
As a
agent.
dual agent, I am
No,
representing
you're
the
not
seller.
you're not a dual agent representing the seller. It's your company's listing. It's not your listing. So your company.
Excuse me,
if-
you're
if
right.
it's-
So I'm representing the seller.
That's
Correct.
correct.
Correct. So I'm representing the seller through the listing through my brokerage.
So
Correct.
one of the things in commercial real estate is sometimes we have open listings. So I am not representing the seller, and I can show to a buyer, and I don't represent the buyer. I represent no, and by the way, they could transact without me and cut me out. So I do it at my own peril, but I am allowed to do it. As Amy was saying, it's unwise, but
If you want to get compensated, it is unwise.
yeah, yeah. You should represent one side or the other, but I don't know. Do we want to make that a matter of law? I don't know that we want to.
Then the other problem is obviously if you're showing another company's listing, it says in the agreement on your MLS, it says that you are buyer, they're paying a commission for a buyer broker. If you don't have an agreement, you're not a buyer broker.
Right. So you're
But
representing no one.
But don't forget, we can't go by the MLS because not all agents are on Smart MLS.
That's true, but they're normally commercial, especially. There's different situation. in
Even
most cases.
residential, they don't have to be. They could do it through Craigslist. They can do it lots of different ways. So we have to make
Yes,
the rules.
but Peter, I still have a buyer agent. So if it's an unrepresented seller, I still have a buyer agency agreement with my buyer that says how I will be compensated. I try to get that commission from the seller, and if I don't, the buyer agrees to pay for it. But I, as an agent, am still representing someone in that visit to a property, which I would, in an unrepresented seller situation, I would really hope that the buyer would be unrepresented if you're going to a property with them. Or I'm sorry, that the buyer would be represented if you're going to a property with them. Because then what's the point otherwise? Like, why are you even there?
Well, it depends. I mean, in some cases, I'm doing that where I'm putting this together, at my peril, because I'm trying to acquire the property and I need a tenant in place in order for me to acquire the thing. I guess then, am I really acting in the business of real estate, or am I acting, for my own acquisition? I don't represent the buyer, or rather the tenant or the lessor in that scenario.
I'm sorry, you're representing yourself to purchase the property?
Absolutely. So there's a person who owns a property, they're unrepresented, and there's someone who wants to lease the property who's also represented. If I put them together, now there's cash flow, which enables me to acquire the property. But then I'm not really acting as a broker. I'm acting as a principal.
Yeah, that's this. I think, Peter, we're getting off the thing here.
Yeah.
Right.
Let's focus on a normal real estate transaction.
And I do understand, however, there is a difference between how commercial acts and how residential
Yeah.
acts.
Yeah. That's true.
I agree, but we can't follow what the Smart MLS is because it's not all encompassing enough.
I'm
At
not,
least that's
what
my
I'm
point.
referencing is not related to Smart MLS at all. I'm talking about how I get paid and who I represent. And the paperwork that my buyer signs says, I will try to get commission from the seller. And if not, buyer, you're on the hook to pay me, whatever that percentage is,
Yep.
or a flat fee.
It's a
That could-
best
that could
practice
be-
and it's
But it
wise.
shows that
but-
I represent that buyer and I'm working in their interests.
It's a best practice and it's wise so that you get paid. And my question is, we have to worry about the consumer, not whether the agent does things at their peril and doesn't get paid or not. So,
No, but it also represents me. It also protects the consumer too. Because I'm not, and I guess now that we've added confidential information and prospective client to the definitions, that protects people's information that they've shared with you if you don't represent them. But again, why would I ever show a property where I'm not representing someone? Like, I'm not a door opener. That's not what I do.
Because some people may not feel comfortable signing an agreement upfront. And that's really, I think, where you hear this most, is that we have consistently heard pushback of people don't want to sign a contract with us.
Okay.
I don't care if it's a day, a month, 6 months. They want to go see a house. They want to go see it today. They don't want to sign anything. They don't know you. But
And I
they're
don't know
also
them.
not-
So also, right, I don't know them. So that puts me in a bad place too, because I'm meeting strangers I've never met before. I have no affiliation with, no relationship with whatsoever. So I'm meeting strangers and letting them into a seller's house.
But we all know it happens. And that that buyer might not have 2 nickels to rub together, but it's still happening where people will go out and they'll do showings, and maybe they do have more information about the buyer, but the buyer just still isn't comfortable signing anything. Because again, they want to know what type of realtor they're getting into, just whether it's personality, whether it's background, whether, it's how much they know about Tudors versus colonials, whatever it is.
So that's also the question, does a consumer have a right to be unrepresented?
Sure, of course. With the listing, they can see it unrepresented with the listing brokerage.
Can they?
Yes, of course.
If we add this law, they can't be unrepresented. They must be represented by someone.
Depends how you write the law, right? So you can say that an agent or a licensee
Agreement.
must represent either the seller or the buyer or both parties.
But so then I, as a consumer, can go walk into a property and so I again call Jill, who's listed on the lawn sign,
Yep.
and say, I'd like to come see 123 Main Street. I go
Yep.
in, and then I, as like average consumer, think that as I'm talking to Jill, she is potentially going to be representing me. So she's looking out for my best interest, but Jill doesn't have my best interest at heart.
No, but Jill should have provided you with the real estate agency disclosure form that says she represents the seller. Right? So every showing I go to for a listing, I bring that form with me and I hand it to the person and I say, I represent the seller. Please do not give me any personal, financial, or confidential information about you that you do not want me to share with them. And you look at that property and they go on their merry way. I just actually sold a listing I have where a buyer came to me that way. I said I did not want to do dual agency with them. I sent them to an agent in my office. The agent in my office is helping them. So they were completely unrepresented. They wanted to work with me and I was like, I don't want to do dual agency. So, they had no representation. They were able to get representation with whoever they wanted. And if you go through the listing agency, you can absolutely see a property without having an agent.
But Amy,
Or go to an open house, right? Like when people go to open houses, the listing agency is representing the seller there. People don't have to sign anything to see the house then.
But Amy, what you're saying is you can't even talk to anybody. I'm not going to show a house unless I know whether or not they're pre-approved to even be looking at the house. Then I'm not representing the seller.
Yes, we can, because you're not sharing that information with the seller. I mean, I ask people, are you pre-approved?
No, that's why I have an issue with the way that it's written, that they're saying it negotiating. I'm going to ask every prospective buyer whether or not they're pre-approved. That's
right. I do that already, don't you? Like if somebody says they're pre-approved,
but the way that was written that we were talking about the other day was then you're considered negotiating with them, and you can't negotiate unless you have a buyer broker agent. So
no, you're getting you're at that point you're getting confidential information, I believe, which you cannot share with a seller. So like based on that new definition.
I can share with the seller whether or not the person I'm showing their house to is approved.
Correct. But if they say to you, well, I'm pre-approved up to 500 and it's a $300,000 house.
But that's not what we're discussing. Of course not. But that's not what we're discussing. We're discussing whether or not you can even show the property. That whole negotiating thing, the way that it's written is you're considered negotiating with this person simply by asking if they're pre-approved and asking for a copy of that pre-approval.
I don't agree with that. I don't agree with that understanding of the verbiage.
Okay.
Well, this is, again, even if you don't have any information from the person, even if, again, I just call you and say, I want to go see 123 Main Street, if you're representing the seller, or if like I just found your card from like any random place and just called you and say, I want to go see this property, then you're facilitating a transaction between the buyer and the seller by setting up that showing. Now, do you
Right,
need a
and I
buyer
should, and
representation
currently I
agreement?
should represent one of them.
Well, I think she's saying it's any property. So not necessarily it is your property.
Right, so what I'm
Notice.
saying is currently the policy we've been following, I
Mhm.
need to be representing somebody when I'm showing property.
I think we're
So
talking.
can we narrow, I'm gonna further narrow the issue to be able
That's
to
fine.
say, to see if like we can at least start on a path of consensus. So I guess my first question is, does a person need a does a broker need to have a buyer representation agreement? If they are showing someone a property, if they're showing a buyer a property that is not their listing, and it is for residential and not commercial property.
Currently, no.
Yes,
Yeah.
based on the current policy that that the commission has in place that we've been following, yes, you
Okay.
should have a buyer agency agreement in that case.
My question is though,
Residential.
is that what the policy, is that what you want the world to look like going forward? Is that regardless of how you're interpreting it today, is this how you think it should be going forward? And that's
Frankly-
what I'm hoping is the first thing that we can poll the members on, because I know we haven't heard from everyone.
Again, we're going back to where we've discussed before. Okay, an agreement must be at the first personal meeting concerning.
But separate apart from this, because let's separate apart the first meeting. So it is prior to doing a showing of a residential property that is not the broker or salesperson's own listing. Do they have to have a buyer representation agreement prior to doing that showing?
Currently, yes.
And so is that how you would want it to read going forward?
Do you think that policy is correct, Sharon, and should continue essentially?
Well, I have mixed feelings on that. I like the old sub-agent. You know, that at that point, if the buyer refuses representation, you would be acting as a sub-agent of the seller.
But I believe we've gotten rid of sub-agency,
Yes,
correct?
I know, correct. It's been going for quite a while, but
That means you can't show it, which makes it very hard. If like Sharon, someone wants, you're my best friend and I want to try you as an agent, but you know, let's go out and see how we work together before we make a decision here. I'm not sure I want you to
Yeah,
represent. your-
then the way it is, you would sign it specifically for that property.
Yeah, that's how it's currently done. Yeah.
That's
Well,
how it's
you can-
done.
you can
Yeah,
do an open
currently, if
agreement.
you're not sure.
You could do an open agreement with a buyer. You could do an open agreement with a buyer.
You can actually. I think most brokers disallow it, but you
Yeah.
can.
I
I
wouldn't
didn't
do
even
it.
know that. That solves
Yeah.
it.
Yeah, you could do an open buyer. That's correct.
So Commissioner Rinaldi, would a buyer representation agreement be required? You know, or do you think that a buyer representation agreement should be required going forward based on the way we're going to be, you know, proposing a draft prior to doing a showing if the broker or salesperson is not the listing broker or salesperson?
Well, yes, that's the way that I do, because that is our current process, and so it should be, because that's how we get paid, is that by representing the buyer if it's not our listing. So yes, I guess the answer is yes.
I would say yes also, because it gets to a point that, and then at what point do you have an agreement with this buyer? This could-
And
I could
Yeah, I
see,
mean, at what point does, if you don't have a representation agreement with the buyer, and let's say you've shown the buyer, 10 houses, And then at some point you're like, well, now you have to sign this representation agreement because I have to write this offer for you. And then they balk. So what do you do then? And they're like,
Well,
oh,
you-
I've decided I don't need to work with you anymore. Right? So you've given them a
Well, the
bunch of
shame on you.
information, you've represented them, you know a ton of information about you, about them. And then they're like, nah, I've decided I don't need you. And thanks for your help. Right? So again, this is self-serving in some respects.
By the way, I now agree. I changed my position. I didn't realize that an open agreement was an option. So, my concern is that I want the buyer to have choices of agency. So now that I know they can have an open agency agreement, whether brokers allow it or not, I now agree. There should be, and I also agree I agree with Amy's point. At some point, you're negotiating, and it becomes murky later.
Yeah. Well, those are
Mr.
brokers.
Ellis? Sorry.
Those,
I agree.
yeah.
All right.
Yeah, I mean, I guess obviously you understand my position and agree. I feel like the paperwork we have, there's enough flexibility in it where you don't have to lock a consumer in for a long time or for, a large geography. You can do a one-day buyer agency agreement for one single property. And while I understand that some agents can be predatory and don't do that, there is the flexibility there to do that with buyer agency. And I don't understand if I'm going to a house and I don't represent the seller in some capacity and I don't represent this buyer, well, who am I representing? Myself, I guess, in that case, right? I'm really just representing myself.
So then, just to further clarify, should this apply to commercial as well, or no?
I mean, if Peter says that an open agreement, which, I believe in CTR's forms library, which also mirrors off of GAR, there is an open buyer agency agreement form. If that's allowable, I don't see why, it wouldn't be possible for that to be used as well. And then if, commercial buyers, if their business practice is more kind of loose, then an open agreement covers that.
I think also commercial, you say loose, but not necessarily so. In many cases, they're dealing with large clients. These clients, they have an internal type of agreement between agent or agencies and that particular client itself. So it falls into, they have different agreements, right, Peter?
It does, and it's complicated, and we're also dealing with sophisticated clients who have
Right.
legal representation and, often in-house legal counsel and so forth. It becomes burdensome, and I can tell you that it's not the industry standard, not just in Connecticut, but in most states. It isn't done that way.
So do we exempt out then commercial for now from this requirement for buyer representation agreement? Commissioner Gray?
I'm in favor of exempting it for the time being.
I think in a way, as we do have the facilities, if they want to use an open or whatever, they can still operate as such. I think by making an exempt, then all of a sudden there's got to be some confusion here. And maybe there's an agent who is a commercial, but actually sells residential 50-50. I don't know, but I want to keep it simple. As I said at the beginning, and go right to the point. Yes or no? Should they have an agreement or not? With the buyer to show a piece of property.
Okay, so then Commissioner Castonguay, you would say no, that they should not be exempt.
I'm sorry, should what?
So you're saying there should be no exemption for commercial then? In your opinion?
I don't think they should be exempt.
Okay, and then Commissioner Berquist?
I mean,
As long as the open agreement allows them to continue how they do business practices, I think that's fine. I don't practice commercial at all. And it's a totally different animal. So, I think we need to accommodate everyone. Whether that's exempting them or not. I don't know enough, frankly, about how
Okay, so-
commercial is run to.
I'm putting you down as abstaining. But then that's fine. That's absolutely fine. Just so I can get a better idea of where everyone is. So Commissioner Ellis,
I agree.
there
Ben,
should be an exemption.
yes.
Commissioner Rinaldi?
I think there should be an exemption.
Does any of this play into my reading of, which I think we'll get to later, commercial agents where you don't necessarily even have to be licensed in the state to practice commercial real estate. That was my reading of the commercial agent statute.
Yeah, isn't there a go around with being
It
from the
seemed like there
state and
was.
commercial? There is something, yeah.
We can, maybe we'll touch on that.
Okay,
Commissioner
when we get to
Vance.
that, we can bring it up again, but
Yes, Commissioner Vance, I actually didn't get your weigh in actually on the buyer representation agreement for residential or the exemption for commercial. I apologize for that. Can you hear us or?
I don't think they should be exempt. The commercial. Only because, not so much, again, it's the ones who are doing maybe 50%, maybe only 25% commercial, and the rest is residential. They're gonna flow back and forth.
We're not exempting the human, we're exempting the transaction.
correct.
So 50% would be required to have the buyer representation agreement, 50% wouldn't,
Mhm.
in your example. Okay, and then so my final thing on this one for now is, so for a buyer that is going to see a property with the listing agent. And so, and they have a listing agreement with the broker's a listing agreement with the seller. They just call based on the lawn sign. Is a buyer representation agreement required there, or just providing the real estate disclosures?
I would say just the disclosure, because I am like, you have to do your seller client justice and let in as many people as possible. And so, I don't have to represent the buyer in that case, because I am representing part of that, half of that.
I agree, as long as it's disclosed.
The disclosure, yeah, and the qualification as well. You would have the right to ask that question if they're pre-approved. That's why I keep going back to that negotiating. I hope we go back to that today, the definition of negotiating.
So in the interest of time, we were not going to go back to that today. What we are going to do is try to get through the document that we sent through the other day. There will be additional changes that we'll be sending out based on our conversations, including revisions to the definition of negotiate based on Tuesday's meeting. But today, we just, rather than going back and rehashing things that we've already discussed, we're going to try to get through the remainder of the document.
I agree with everything that was said by Sharon, Amy, and Ben.
I agree too.
That was an easy one. All right. Perfect. So getting back to the document, I am going to share my screen. And again, this is the document that you all received earlier. No, actually last month, earlier last month. So we had stopped on page 20 in section 20-314. For those of you that might not be able to see my screen.
Unfortunately, we don't have pages here. What page are we on here?
20. So if you look in the bottom, are you looking at a printout?
We're looking at, which has no numbers.
Oh, okay. So I'm looking at the page numbers of the electronic version. So so if you find section 314, it's further up, but then we are in right above subsection G in 20-314. So one of the things, I believe this is where we stopped, was talking about for reinstatement, how we would require continuing education to be completed prior to reinstatement, and put in that the person would have to complete at least 6 hours of continuing education prior to reinstating, but wasn't sure if that was an appropriate number. Looking for feedback from the commission on your thoughts related to that. It's just making sure that someone's kind of kept current in the field. There's no strong feelings on that, then we can kind of move on. So here, what we did put in is just a little bit more detail about when a hearing denial. So when we refuse to renew or issue a license, that if someone's going to appeal that decision, they have to request a hearing within 10 days, rather than just letting this request for a hearing go on forever.
Is 10 days enough of an opportunity? Is that fair? Is that enough time?
I mean, it is what we have in other areas of law. So for example, with like home improvement contractors, we have this, trying to think where we just
I mean,
put it
my
in
fear
like-
is always, my fear is always that I want to give everyone every opportunity within reason.
Wouldn't you think 30 days would be a little more reasonable than 10? I don't know.
30 days seems, like it should be adequate. 10 days is very tight.
Okay.
Well, can it be done in 10 days? I guess they said realistic. Or should it be 15 or?
Oh yeah, you have to send an email that just says, I would request a hearing. So this isn't a petition to court. You don't have to file official documents. They just have to request a hearing, saying I don't agree with this denial. So that is typically why it's been a shorter turnaround. But
I mean, I was actually, in truth, I was thinking like 90 days, but I mean, maybe that's unreasonably long. I don't know.
Yeah,
we prefer to keep it much shorter than that. So
I think
and
30
typically-
days is fair.
Okay, all right, change that to 30. And then, so now we're getting into kind of courses and schools. So I think we started talking about it a little bit last time, how we're separating out the course registration versus the school registration and how that's going to be handled. So dealing with, again, registration of schools and related to pre-licensing and continuing education. We have in here starting to touch on this is language that was already in there about how the schools can be taught or the course can be taught online. And then we really, in this next section, move into how we're going to be handling schools going forward. So now schools are going to have to apply. So currently it's really they're submitting in their courses is how we're reviewing each individual course. So now we're going to say the school has to apply and give us information on who their teachers are and that they're going to comply with the statutes. Now they don't have to give us a list of teachers, but they're going to attest to us that their teachers are qualified to be teaching these courses. And that's based on section 314D that we'll get to shortly. And that their courses comply with the requirements in the section as well, especially related to how they're offering them online. So that we have a hook and say, if they're not checking in to make sure people are really taking the classes, they're offering an online course that's supposed to be 3 hours, you can complete it in 1 hour. We don't have to start auditing and investigating each individual class. If we find a pattern in practice of deception, then we can revoke the school credential and they can't offer any of their classes. So the registration would expire every 2 years, and we wanted to make it so it's not a huge hurdle for the people to be able to register and get these. So we just did a renewal fee or an initial application and renewal fee of $100 per school. So basically $50 a year. These are this is language from existing regulations about how the teachers have to be qualified. So we did not change those requirements. So either experience as a real estate professional or a professor.
So what happens if, for example, we just had the crumbling foundation issue, right? So you would have potentially an inspector or a structural engineer potentially could give a class related to that, but they are not a real estate, they're not a broker or a licensee, or don't necessarily have a formal education training program experience. So is that person's just simply disallowed from teaching?
Oh, I would say that person, assuming they've been structural engineer for a while, is a professional with a designation in the area they want to teach, so that professional can speak to the group about pyrotite and,
Okay.
the web cracking, stuff like that.
All right.
Typically, I thought though they make great guests, but should they be leading the instruction? I would say they shouldn't be leading the instruction.
I agree with Peter on that one.
Okay.
So, I mean, based on this, we wouldn't have, I don't know that you would have a basis for denying that course though. So if it is a structural engineer that's going to talk about how to identify the crumbling foundation issues, where the issue has been present in the state, like generally how much it costs to replace, like what are the options for a homeowner. I don't know that you'd be able to deny them based on their experience in the field. Again,
Wouldn't he be considered as a consultant though, Julianne? Consultant to the instructor?
no, why? Why couldn't they teach? Because I mean, again, this isn't existing regs. It's just that they're a professional in the field that they're wishing to teach the class in.
Mhm.
Specifically related to real estate. I mean, I don't know if this is something that you found prevalent in the field so far, because again, this is not a change in law. This is
Well, the other thing is do we have to, so 5 years of experience as a practicing broker, I think there are sales professionals that teach classes though. So does that fall under that second part, or professional designation from an institute or society?
And I am not a broker. It would eliminate me from teaching. I teach PMP, so it's the practicing broker.
Yeah, so can you say sales associate as well, or?
So I have a question about that, because I've been when I took my broker's license, I was taught by a salesperson, and I know in higher ed, for example, you can't have someone with a BA teaching master's classes.
Why did you have to take PMP? Because it had been, you took the 30-hour class, you fell into the 30, so you had to do 60.
So maybe I'm calling it the wrong thing. I had a salesperson's license and I was upgrading to the broker's license. So there, I needed to take the broker's classes and also
And
the
that was
legal.
taught.
Yeah. And it was kind of funny that the broker's class was taught by a salesperson. And I will say she was fabulous.
So, or designation,
all right.
experience as a practicing real estate licensee, unless you want to keep the broker, and then I'll retire.
Do we want salespersons teaching brokerage classes, or do we want salespersons only teaching salespersons classes and only a broker can teach brokerage classes?
I agree with that.
I feel that that's how it should be, although that's not how it presently is.
Do you want to make it that prescribed, or do you want to open it up so it can just be 5 years of experience as a practicing real estate licensee?
Was that question for me or to all of us?
Oh, to all of you, sorry, to the entire commission.
Well, like you said before, Peter, you felt that that particular instructor who was a salesman did an excellent job. I guess it's we want the best qualified person. Simple as that.
And it sounds like this is being done currently. So
Being
She
done-
was fabulous. And I will say that even though she didn't have a broker's license, she had probably 40 years of experience as a salesperson.
Commissioner Costello, I do see that Cindy Butts has her hand up.
I agree. I'm sorry, who? Cindy?
I just wanted to bring up all of the ors in number 2, which is, so under 1, it says you need to be 5 years as a practicing broker, or 2, experience in teaching in a formal education program, or attendance in an accredited college or university, which is at, I believe, the instructor seminar that UConn does. And then it goes on about for collegiate level courses. So in this, do all of the 4 ors apply? Because if they do, then for example, in Sharon's case, she has taught in formal education programs for many years. Isn't she able to do it because of all of the ors that are incorporated throughout this? Oops.
I don't know whether, and I have to go back and talk to, a team that does this as well, but I don't know that the formal education program would necessarily be a real estate continuing education courses or those kind of school courses. I think that it typically would refer more towards a college or university level teaching, but
Well, and then there's again, the 4th or that says that you just attended an extension instructor seminar, which I believe is why that instructor seminar is offered twice a year for anyone who wants to take the instructor seminar. That's the 4th or in here. Yeah, and I also just want to note, as Jim did at the last meeting, that CTR is going to review all of this as well. I mean, it's why you aren't really hearing us weigh in yesterday or today on any of these topics. We're taking a lot of your feedback back to our committee as well, before we know what our position is. But this is a current issue that we have, which is, does or mean or?
Or definitely means or. So for example, one of those I believe is that you taught in an institute of higher ed. So any college professor can teach this even if they don't know real estate, whether that's intended or not. That's how it reads.
Well, Peter, at the first part, it says for collegiate level courses and degree programs, comma. So I thought that applied to just collegiate level courses, not to the rest of it. The rest of it is the first 4 ors.
Maybe you're right.
you have to read who does not have experience in a teaching course or experience, or who does not have attendance in a accredited college or university extension seminar. Right, this is a separate sentence. So, I mean, we can certainly answer your question specifically that, it sounds like you are aggregating and going to be sending over to us, but yeah, if there is a feeling by the board that, or the commission rather, that this is insufficient, then please, let us know.
Seems like it's working well, and I'm not hearing about complaints related to this.
Huh. Yeah, this is existing law, so.
We may not be hearing them. The questions are there. Has this been a problem?
Well, if there are, if there are ways that you can talk to your colleagues out there who might be teaching or in any way engaged in this type of, course oversight, then it'd be great to hear. I am not personally aware of issues related to this, but that doesn't, like you said, that does not mean that they are not out there.
So, I mean, for me, and I'm sure you guys too, I'm affiliated with Bridgeport Board, and the instructors I talk to are really enthusiastic instructors. And just the students I've talked to, you know, the classes I've heard are really fantastic. So I haven't seen this as a problem. I don't know about you guys, just wanted, that's my 2 cents.
Yeah, I mean, my only concern is that I think there are a bunch of sales associates that are teaching classes right now, and a number of them are good instructors. And so I'm concerned that they may not be covered because we specifically say practicing broker. And I don't know what happens if they're no longer allowed to teach and what that does to the available classes.
I don't
It
think
becomes
there's,
a problem.
yeah, I think, I haven't heard any pushback on this call, to just changing it to.
Okay, so yeah, so that's my only, I think it should just be expanded a little bit. That's all.
Sure.
Thank you.
So then course requirements, and this is also generally, taken from existing law. Some of this is just based on the clarification we also did with the commission related to what needs to be submitted for course approvals now. And so, course outline, names and the contact information for the instructors, have your certificates to be issued at the end, so we know what we're looking at, that people actually have authentic certificates from the classes. Cancellation refund policy to students, so they know exactly what they're getting. And an attestation that they meet all of the requirements related to how courses need to be presented. And then if it's taught in person, just the location of the course. So that is, and in there, so there's now going to be a fee though to register each course, which up $50.
I'm concerned about, there's a lot of fees. How much was it it was free to register the class previously and free to register the school, wasn't it?
Yes.
So I'm concerned that takes the small players out. I mean, there are people who are teaching small classes who are good teachers. And I'm concerned about the accessibility of classes for people.
So we wanted to keep the cost low, which is why we put in, the initial license and renewal fees for the schools of $100 every 2 years. So basically $50 a year. And
To me,
then,
we should either be charging the school for registration or per class, but to both, it seems a little much to me.
so it is a one-time cost for the school. Oh, sorry, it's a one-time cost for the course.
So I can pay from $50 for that course, and I can teach that course for the next 20 years.
I believe, and Ben or Ryan, step in if we did change, but I believe it does not expire. Correct?
I would have to
Unless it's
review that
modified.
section. I can't say
Okay.
with certainty.
If it doesn't
taking a look
expire,
now.
then it's a nominal fee. It's a one-time thing, and I can use the course for 10, 20 years or whatever.
Yes, again, we'll double check, but I don't believe it expires. The school registration does. So again, they all have to be approved by the department in advance. We want to make sure that one complaint we have heard in the past, people will offer classes, they'll say, it's a 3-hour course, people can complete it in half an hour. We want to make sure that that does not occur anymore. Specifying that it's a live online course format, and this is just based on conversations we've had extensively with the board in the past related to how these courses are presented. So you're allowed to, so this allows you to engage with the instructor during the course of the class.
Quick question about time. If it's a 3-hour course, does it have to be 3 hours to the minute, or what how are we going to, how are we handling that?
I mean, I think there's a little bit of like real life that plays into everything. I know that I've certainly been released from continuing education courses 15 minutes early, and still expect that I get my full CE credits.
So I think there's enough shortcuts going on right now. I don't think we need to, I think we should keep it at that minimum.
Yeah, because we also get to determine which cases we prosecute. So like if you get let out of a course 10 minutes early.
Okay, so what you're
Probably
saying
not
is
going
if it's
after that professor.
reasonable, it's not going to be, if it's reasonable, it's not going to be prosecuted. If someone is piggy about it and it's 30 minutes for a 3-hour course, that's a problem. That makes sense. And I like Ben's idea. Keep it simple. Don't define it. 3 hours is 3 hours.
Yeah, and that's what, I mean, that's really what the expectation is for us. So, so actually this actually does have the registration expiring on a biannual basis, which I also shall spell drugs. So I'm gonna just check that out. But so
Does that
I guess
mean
the class. Go ahead.
do the classes expire or just the school registration?
The way it's written right now, this classes also expire every 2 years. So the question then would be, should that be a longer period of time? And if so, how long?
By the way, I want to tell you guys, I don't teach any classes, but I'm friends with a lot of people who do, and it's not an easy way to make a living. And I really hate to see too much financial burden put on them because they do a good job for, and the courses are like $50 a piece. It's very hard with 5 or 10 students at $50 a piece. It's very hard. I hate to see more burden put on them.
I think there are a lot of classes that wind up being proposed to the department that it takes a lot of time right now for staff to go through and review these.
But there also are shortcuts. For example, if I take a Deerfield course, I can go by Deerfield and they only charge me per booklet and they give me a packet and I submit it to DCP and you guys say, oh, it's Deerfield. We've approved that one in the past. Or, same thing with, NAR courses, oh yeah, we've seen those before. So a lot of them I imagine are quicker in that way.
I certainly would defer to our staff that reviews them in terms of how long it takes to review each one. But I think in terms of making sure that course content remains current, we don't have because right now we have classes that they don't expire. They just remain on in perpetuity with us. So we have a lot of classes that probably aren't still being offered. It is certainly advantageous to have a time frame where they drop off. So we can say this class is no longer currently, unless it's re-registered, it's not a current class with DCP. Whether 2 years is the appropriate amount of time, I do not know.
If it's a good class and it's the same class, there's some classes that are no longer going to be relevant. So when you go from, 40 or from a 30-hour P&P to a 40-hour P&P or whatever it is, the old class is no longer any good. So so that they become obsolete. Or same thing with continuing ed, a lot of them become obsolete because they no longer meet the objective. So, to me, if the class is good, it shouldn't expire. It should last, if not forever, certainly for 10 years before it's re-reviewed. And, I don't know how to do this. I did talk to Jill about this, and that's how I know, for example, the Deerfield class, if the DCP has seen it before, they already know, they've seen the deck. So, I am concerned about the amount of burden put on some of the teachers, especially for classes that the DCP has seen umpteen times.
I think the counterpoint to this is the idea that you have, real estate law courses, you have landlord-tenant law, you have, issues where there are changes over time. So would it be reasonable to extend it, you think, for 5 years? because then it's $50 every 5 years. So it's basically, it would be, it's a course you're continuing to offer, it's $10 a year.
I mean, to me, I would love to see 10 years. I'd love to see them really get some value and really get some teaching and be able to earn some money for themselves, and so that they can continue teaching.
As long as the contents doesn't change, which can, based on laws. Do we change?
And people don't always reach out to update us. Like, that's just the reality of it. But I think, we only really wind up getting current submissions, and it's not just, with real estate course providers, it's with anyone. Like, you guys update your email addresses or your phone number. The first thing that you think to do is not to go on e-license and update your contact information.
So
Like, it's
maybe
just,
5 years, maybe 5 years is more reasonable.
Okay. All right. Well, let's flag that in for now, and we can comment more on that in the next draft. So, like, oops. I was on the wrong screen. So then for refusal of license, this is not, there was no changes there in section 11. So section 12. So this has to do with when people are licensed in another state and they're going to be applying here. So I know the brackets and underlines make this all look like a mess, but so when someone's working in another state, they're licensed in another state, then we are, so we can recognize their license here, so basically give them, equivalency, provided that the applicant so they have to establish their competency by written examinations, and that the other jurisdiction allows licenses to be issued to residents of Connecticut without further examination. So this was legacy language that was in there, and we didn't necessarily know why there was this idea of people being granted, or that we needed another state to give permission to grant this equivalency to folks who are licensed in another state. Wasn't sure if this was something that anyone had any historic knowledge of, or otherwise we just leave it to the commission to determine equivalency for people licensed in another state. We don't need to have the permission of such other state.
But with them still taking the law portion, correct? Or passing the law portion exam.
Yeah, so they have to have their competency by written examinations of the states, and then also, sorry, I was doing another section. So this is actually, and that they had to grant Connecticut licensees the ability to waive in without examination. So basically, unless you'll do it for us, we won't do it for you.
And as I recall, some states you waive in and there's no examination, there's nothing. Other states you waive in, but you have to take the Connecticut portion of the exam.
And so we were just saying, are you guys okay with us eliminating this whole tit for tat and just say, if they have equivalency, they can come in?
I don't know, some states, it's too easy to get a broker's license. I'm concerned about giving these away. These
No,
the states where we have.
You still get to determine equivalency. So this is not, you can say, oh, no, Texas, your standards are too low.
Yeah,
That's
but
not
do
what
we
this-
want to, as a commission, get involved with figuring out what other states do and don't do? For example, right now, the reciprocal states, we know that they have standards that are acceptable because we've been doing it this way for decades.
But you already have to determine whether they have similar standards to Connecticut. So that assessment already needs to occur. The question is, if there are similar, so let's say Massachusetts and Vermont both have the same standards exactly for real estate, and they're substantially similar to, or higher than those in Connecticut. But Vermont says we won't allow you to waive in, we won't allow Connecticut people to waive in without, taking a test. And yet, what was the other state I said? Rhode Island, I think. Rhode Island will let someone go waive in without taking a test. We're going to say, well, since Rhode Island's kind to us, we'll accept Rhode Island people, but we're going to say Vermont people, you have to have a hard time.
I like tit for tat, but maybe I'm being, difficult.
It's, the question is in terms of equivalency, the equivalent standard is the same. So it's the same people with same qualifications. It's just, are we holding their state laws against them? People are generally okay with this. I think that
How
our
many-
recommendation is to take this out.
Julian, how many states now are we reciprocal with?
I do not know the answer to that off the top of my head. I know we have a list, but I don't know.
Over 20.
Over, yeah.
Okay, so, and this is stuff that's in there, like, please, I hope that if you guys have questions or comments that, even if you don't necessarily want to flag them right now for everyone on the phone, I'm happy to take emails in, or any of the team, you can email us directly with further follow-up on these things if you have additional thoughts. We did change the language related to where people could receive lawsuits, or how people could be sued. So this whole fee section is out. But that is just formal, more of a technical thing for how suits are filed. So let's scroll down. What we did here for continuing education is that we had written in 4 hours for leasing agents for continuing education every 2 years. This is not a number set in stone. That just seemed to be what would probably be reasonable in terms of focusing on landlord-tenant law, security deposits, fair housing, stuff like that. So 4 hours there. Then okay, and then here, this is a whole section. So this whole section in 319 is all about continuing education. So we did just split out the subject of pre-licensing to another area. So this is where, when we're talking about regulations, the regulations in this area that we're authorized to draft, which was already part of the law, is just related to the CE. So some of this is just clarifying. What we did put in, and this is something we've been doing with other boards as well, is this idea of how we deal with failure to take CE. We have had a lot of issues in the past of trying to bring enforcement actions, bringing enforcement actions against licensees that fail to get their CE on time, and then it winds up being an extremely cumbersome process of bringing people in for compliance meetings, doing all of these individualized settlement negotiations, doing administrative hearings, and it takes up a ton of time, and it winds up being quite an aggravating process for both the licensee and DCP.
This is better. You just charge them a fee.
If you do it based on, once you renew, if you fail to pay for it originally, it winds up being much easier.
But are these fees too low? I mean, we really want to discourage people from not taking the CE.
This is what it is for architecture and accountancy. That is the only
Okay.
basis for this. I have no horse in this race in terms of they are too low or
I mean,
too
for
high.
me, I would love to see it be a little bit punitive, but I don't know if I'm too punitive.
Is the department using these numbers to be consistent, by the way?
This is just, this is what accountancy and architects use. Architects use it because accountants use it. And accountants haven't updated it in a long time.
They look low.
Yeah, this is statutory plagiarism. That's why I will admit that. So does anyone else have a thought of what might be a more appropriate number if you think it should be amended?
I think it's reasonable. I mean, there's a lot of, and why I say that, a lot of people come in front of us because of maybe their health or other reasons, because of CE, why they didn't do their CE. And I know it's a lot easier now than it was a few years back to get it completed, but I think this is reasonable.
I think especially this year too, the next cycle is changing to you have to complete it 2 months prior to renewal. So there might be
And the confusion at times it is, it's simple, I just think it's reasonable. That's just my feelings. Not trying to sway anybody, but this is my feeling.
And just remember, all of the sections in here that the way we have it proposed right now would not be effective until April 1st, 2024. So, all of this is down the road quite a bit, but
I like 500 and 750, but it's not the end of the world if these are the numbers.
I mean, if anyone else feels strongly about that, I guess if you want to shoot us an email and then we can kind of get a better pulse of.
Well, anyhow, Sharon and Amy, how do you feel about this?
I think 500 and 750 is good.
I don't have any problem with what's written currently. I mean, if you want to up it, that's fine. I don't have a strong feeling either way.
Commissioner Vance, are you able to speak yet or no? All right. Well, maybe.
Ed, can you hear us, Ed? Ed?
I don't see him on anymore.
He's here.
Oh.
He's just muted.
Oh, there you go. Now I see him. Okay.
Ted, can you hear us?
There we go. Okay. Yeah, I'm sorry.
What's your feeling about it?
Yeah, I think you'll usually like to have them higher numbers. In this case, I guess, I don't know. I would think 500 and 750 would be okay. Well, I'm not outraged by what you've got here.
Okay. Well, then we'll take a, we're going to make a flag. Ben, if you could just put a flag in the document for that.
Okay.
I'll bring that back. So, then this has to just do with transfer of employment. This is specifically the big change here is just when a team transfers to a new responsible broker, then the responsible broker, the new broker has to update their registration within 14 calendar days, making it incumbent on the new broker that has the interest in this new team that's working for them versus, we didn't want the old broker that may be bitter about having their team leave be able to hold up that transfer. So that is something that, you know, we had heard as a complaint in the past. So we don't want to be able to hold them hostage. So we had made the change last time. We'd actually skipped ahead in our conversation a few weeks ago about suspension or revocation, to change the fine from $2,000 to $5,000 per violation, knowing that that is a cap. It doesn't need to be that high, so we already made that change. And then down further in this suspension revocation, it just talks about, you know, how fines are able to be, or how decisions are imposed, how decisions are rendered and how fines are imposed. That's already covered though in the Commissioner's general powers. We didn't want to have language conflict, so we're just taking out redundant language there. And I don't remember which section it came from, but this idea of agency that, you know, you're not relieved of responsibility for the conduct of your employees, officers, is just linking. So, you know, if it is not just the real estate broker salesperson, but if it is their, you know, secretary that is also engaging in certain context representing that real estate broker, then they are an officer of that or an agent of that broker, and they have certain liability for that. So this is, this is also additionally in here in 320A. There were a number of places where they talked about how the department can investigate cases, then they can issue fines and do all of this. That is all now just in the enforcement section. All of the enforcement powers are just in 320, 20-320, and it's just all in the enforcement section rather than having it all over the place. Then here again in 320B, took definitions, moved them up to the definition section. So everything's just going to be a little bit easier to find. Real estate guarantee fund was just updating defined terms. And this is just clarifying that when the fee is paid to the real estate guarantee fund is upon receiving a license. So procedure, this is all just cleanup changes. And here we get to the big change, or one of the big changes in here, which is leasing agents and what can they do, who they are. We talked about this a little bit in the first meeting. So, you know, leasing agents can only be working on residential real property, which is 4 units or less of residential property. This has no impact on a broker or salesperson. So brokers and salespeople can do, you know, all of the work that they do now. They do not need a separate credential to do leasing activity. It's just brokers and salespersons can take on the entire scope of the universe. It's just leasing agents are extremely limited in what they can do. Now, we specified in here what they can't do, and anything related to sales, even, you know, lease to own agreements are also prohibited here. We don't want people doing this kind of runaround saying, well, it's not a sale agreement, but you know, it's a lease to own. So the way that they are able to operate is that a leasing agent either works for a responsible broker, so works for a real estate broker, or they're employed by a development owner. And the development owner is 50 units, as an owner of 50 units or more. The idea of that, when we talked about last time, being that it's a sizable enough property to keep someone employed at least part-time. So if they are, let's say I am working for, you know, Park Place Towers in Hartford that has a ton of units, probably 100+ units, this does not mean that I can work for Park Place Towers and I can work for a bunch of I can represent my cousin in leases and hang up a shingle separately. I can only work for development owners. And if I want to work for Park Place Towers, but then I want to start representing clients on the side doing leasing, I have to be affiliated with a broker to represent individual clients.
So I'm a little confused. So if let's say that I work for Avalon and they have 200 units and I exclusively, I'm an employee of the company. So I need to become a leasing agent to show people a home that they might want to rent. Is that what this is for?
Yeah, so you only need to have that leasing agent credential, and that is it. But you can't then work for them. And then,
I can't engage in the business of real estate. Exactly.
Yeah, you can't go out and then take on other leasing clients. But
what I'm also confused by is it says something that it has to be 4 units or fewer. I don't follow, because this fictitious Avalon has 250 units, and I would be showing units and trying to get people to sign up.
So if you are okay, that's really interesting. This is actually, I think that might be a drafting hole, in the sense that we currently have that, again, you can work for a developer that's 50 units or more, or that if it's less than that, you have to work for a broker. But we say that it has to be for the lease or rental of residential real property, and residential real property is 4 units or less. So that means that if you worked for a broker, unless we amend this, you can't represent a building that has 20 units in it.
Correct. But I'm also but I'm also confused because I don't understand, so I understand if I work for Avalon or whatever the company is, I understand the purpose of that. But if I'm working for a broker and I'm running around and showing 1 to 4 units, I'm really engaging in the business of real estate. To me, that's a person who should have a salesperson's license.
Why?
Because there's certain things, why? Because I don't know, do they know enough about fair housing law? Do they know enough about agency? Do they know the things that, that salespersons are specifically trained in to conduct these activities?
But the whole point is that their pre-licensure requirements and their continuing education requirements are solely based on leasing. So all they are trained on is how to deal with security deposits, fair housing, landlord-tenant law. All their exclusive training is in that area.
And then is there a pathway from leasing agent to salesperson? Is there an upgrade training, or do they need to go through the whole thing again through PNP from start to finish?
They have to do the whole thing over.
Okay, thank you.
Can I ask another clarification question, please? All right, so if I work for a development owner, I understand that, fine, it's the 50+ units. If I work with a responsible broker, that's your regular William Ravis, Prudential, Century 21, whatever. I can affiliate with that broker just with my leasing license.
Yes, we can only engage in leasing. We all have to make sure that
So can I sign leasing listing agreements?
Only a broker can sign a listing agreement.
No. Well, it's tied to the brokerage, but I, as a licensee, whether I'm an agent or like a sub broker, can sign a listing agreement. But as a leasing agent, can I sign a lease listing agreement? So if somebody's renting, the second floor of their three unit building, am I, as a leasing agent, able to sign a listing agreement for that lease? Or no, is that practicing real estate?
Well, they're allowed to practice real estate. They're allowed to practice just a very limited scope of real estate. So I think.
But it says that you, for the listing or showing, I guess listing or showing for sale.
Yeah, so they can. So I think it's contemplated that if you're working for a broker and you want to
just do leasing,
the place, yeah, if you want to list and not just help tenants find places, but also help developers.
Okay,
But I don't think that's an issue.
all right, okay, because it's a separate lease listing, not a sale listing. Okay,
I have a question. I think maybe
Thank you.
this is a little too broad. I thought the purpose was to have leasing agents just be certified, and then you're bringing in, but then they could go to their brokers, a broker's license, and I don't think that's fair that they would. I thought it was more specifically for these leasing agents in these corporate circumstances. And then if it's 20 units, that might be a licensed real estate agent who was handling that, or even if it's 20 units, if they're employed by that owner or the developer or whatever, then they would at least, at the very least, have the certification of a leasing agent, or what are we calling it? A certification or designation?
This would be a license. They would have to be licensed because they have to be trained. They have to take pre-certification class. They have to take continuing education. These are trained real estate professionals. They are just only doing leasing. The concern with doing it for smaller units, like going for under 50. And again, we like Commissioner Gray asked how we came up with 50. So it seemed like a lot. It seemed like enough of time at that place that it's, you know, real, at least like solid part-time job. The concern with it, if it's just doing like 10 unit buildings or 5 unit buildings, is that then this person is going out without having anyone really checking on them, especially with these small development owners. Where are those security funds or security deposits being housed? How are they allocating their funds? It seemed more dangerous to consumers, both tenants and landlords, if you had multiple clients, if that leasing agent had multiple clients without really direct oversight. And that's why we're like, if you're going to take that person away from a large development owner, it really should be overseen by a broker. Because you would expect the same thing for a salesperson to be overseen by a broker. Now, the broker can certainly say, I don't want leasing agents, but I want you to be a salesperson or bust. And that's fine. And the person just, well, they either go and they get their salesperson's license or they find someone else to work with. But yeah, making sure they have that knowledge is really, we thought is really important, but also realizing that, you know, there are these people that sit in leasing offices all day long, just doing the same thing for these development owners. And
Let me just, one question, the mechanics of this thing. Julianne, so who's supervising these leasing agents? Who's the supervising?
it depends. If it's if they're working for a development owner, it's the development owner.
Mhm.
It is the large scale development company that is going to be overseeing them.
So
If it is,
somebody has to have a broker's license in this development?
Yep.
So there's no broker, there's nobody supervising these people.
it's their manager, it's the person that they work for at the location. Because generally, when you're talking about these larger scale developments,
Mhm.
then it is the leasing person is sitting at a desk, taking money, giving it to the business office, filling out like, oh, it's, you know, you're going to start your lease on November 1st and ends October. Like they're filling in Mad Libs. They're not negotiating in a way that typically may occur out if you're dealing with more individual owners.
Also, they're doing it now anyhow. So this is at least an
Well, that's
upgrade.
true.
At least it's something compared to nothing.
You know, we know that. This has been going on for years and years and years and years.
And so if there is an issue with that person, then we can take their credential, we can make sure that, you know, Susie, who's committing fraud at Park Place Towers, doesn't then go to UConn and start working at Seller on Apartments and to start doing the same thing there. And so there's a track record or something. And also, and the big thing is just training them, is knowing that those people now are better equipped to be dealing with the leasing issues at any of these large establishments. Because the development owner may not, we see this a lot of times, that we have developers coming in from New York or Boston or, or Massachusetts, and they don't necessarily become well-versed in Connecticut law. And they may not have, robust training persons for the people that are sitting at the leasing desk. So,
My apologies.
I'm sorry. I have to stop putting it up on that screen, huh?
Okay.
No. So let's just scroll down a bit. So the big thing is that so one of the things here is that, so for leasing agents, I'm sorry, just scroll down. They can't offer, like again, services for anyone who's not a development owner or broker. And that they have to, if they are employed by a development owner, they have to have a written contract with each such development owner. So the reason we wanted to do this is to be able to know, again, just who they are working with and the scope of their activity. So, I could work for both Park Place Towers and Celeron Apartments. I could work for two separate large developers. We just want to know that there is a contract and that there's a specific scope to it, and to be able to say, yes, this is the development owner, they have more than this number of units, and they're only going to be providing leasing activity. And in the event that, let's say, again, I'm working with Park Place Towers and Celeron, stop working with Celeron, then the development owner, or sorry, and I stop working with the broker development owner, the leasing agent has to notify us within 14 days that they have stopped working with that owner, or that they have started working with a new owner or responsible broker. So this just makes sure that we can track where these people are, which is no different than with a salesperson. We want to know who you're working for, who's responsible for your conduct. So that is the crux of it there. So this 325 was just a technical change. So here, related to commissions, and Ben, did we move this?
I'm sorry. Did we move?
I'm in 320 or 325B. Like,
I'm scrolling.
oh,
to it.
no, sorry. This is all right. No, I'm misread. So for the compensation agreement, this is related to just leasing agents. So that's what it is that we have. So the compensation agreement related to brokers is up here. We basically copied it here and just said, for leasing agents, and it's not fixed by law, so that people can't say, well, you have to pay me 3%, or you have to pay me your first month security deposit. So, that is something that that just needs to be on any agreement. In the event that this really comes into play when it is a leasing agent working for a broker. I'm probably dealing with more of these individual clients and entering into agreements than, you know, with a development owner. But so just a consumer disclosure. I think this is all just technical cleanup changes. This was the broker sub-agency. So this was Jim or Cindy. I don't know if you have any further clarification on this. I believe you guys were going to check with the commercial side of the industry to determine whether there's any issue of just taking this whole section out in 325F, the broker sub-agency.
Yeah, we asked a number of commercial agents. They were not aware of anyone currently practicing sub-agency. I don't know if any of the residential commissioners are aware of anyone who continues to practice sub-agency or not.
Not that we know
All right, so then we're going to leave that as is with the section taken out for now. And moving definitions up to the definition section. Same thing in 325L. And yes, just moving things around. There were no substantive changes there. In 325M, we did have a section about recording real estate transactions. So since a leasing agent that works for a developer doesn't have a broker affiliated with them, we had to put in specific requirements related to how they had to do record retention. So saying for 7 years, they have to keep a list of all of the development owners that they engage in contracts with. And they have to have employment agreements or contracts with every development owner they enter into a relationship with. And we're saying that they must be retained in electronic format unless commercially impractical and should be produced upon request. That was the only change to the record retention. So it wouldn't affect the existing licensees. One of the things we did make in this next section was related to housing discrimination and fair housing. So there's a CHRO, the Commission on Human Rights and Opportunities disclosure form. Originally, it said that it's only given to people who offer residential property of 2 or more units for sale or lease. To be able to provide this document, we took out the 2 or more and just said for any unit. But it just seemed like a good thing to do.
I don't know that I agree with that. So I've seen a lot of CHRO complaints, and I can tell you that I know 3 agents, including myself, who've had them that were totally unjustified and painful and difficult. Guilty till proven innocent. The amount of documents that are required to the CHO requires you to come up with onerous. I basically had to shut down what I was doing and only do CHRO homework for 2 weeks and hire a lawyer who specialized in CHRO, who very quickly, by the way, in the end, all that the punishment that I had is I needed to write a written apology, and that's it. There was not an economic anything, because it was and it was nonsense. So that and it's not just me. I can name at least 5 other agents I've seen this happen to.
So, I mean, this is just about giving out a pamphlet, essentially, like a disclosure form about your rights under CHRO. I mean, it is not providing them with any more rights than they have currently under law.
I don't know. I mean, what other rights do we want to provide them with? How many rights, I mean, they've got,
Oh, you want to mute again?
people have gazillions of rights. They have virtually unlimited rights. How many rights do we want to make them aware of? At what point is it, at what point is it enough?
I disagree with you, Peter. I don't think, when it comes to rights, I think it's to protect the public. I mean, it's necessary.
Peter, this also says residential sale, residential property. What would that change, Julianne?
No, just
This
the
one,
number of
the
units.
2 or more units.
Yeah.
Change release for the option of actual such a photo of that. Okay, wait, but it says at time of closing. So you don't provide them fair housing information until closing?
So yes, is how it currently reads.
And that's to try to stop discrimination? I don't know why you wouldn't provide it at the beginning of a transaction, but
Maybe that is the time, at the time of first meeting.
Or maybe upon offer of a lease or purchase agreement. I mean, it's.
Yeah.
I mean, our big thing was just if
Well,
single family purchasers can also be, afflicted by this. And so the 2 or more seemed just, but I certainly take your point of when. So maybe we can take another look at this section and propose some alternate numbers. So Ben, if you can flag that in our agreement as well. So next, so this is actually something that came up from Illinois, and it also was brought to our attention by someone, I believe by someone in the AG's office, related to having a third-party translator that was provided by the real estate licensee. And in the event that a real estate broker is providing a translator for someone to conduct negotiations, that they want that this would require the buyer and the interpreter to sign basically a consent agreement, or to sign a disclosure that says who each party is and then who the interpreter is representing. And so this is just to, now it's my understanding that, limited understanding from not being in this world all the time, but that most people will bring family members or friends if they want interpretation services. Most of the time, the interpreter is not provided by the licensee.
A lot of times the interpreter is the licensee.
So then the real estate, so if the licensee is acting as the interpreter, then this comes into play.
Yeah.
So we're putting in here that the buyer has to sign this form saying that they had, oops, sorry.
I mean, I have that happen frequently.
So, but they're at least going to say, all right, well, I chose to have, Ryan Burns be my French translator, be my Spanish translator.
So I don't, so actually that raises a question. So, there are times when I have, a client, when I have a tenant show up and I represent the seller, the lessor, and I do speak to them in Spanish or Chinese. And I'm not, I am acting as an interpreter. I never even considered that. Am I acting as an interpreter? Or am I just speaking to them?
I think you're just speaking to them. If you're
I'd say
fluent in
that's
those
what you're
two
speaking.
languages, you're just conversing with them in their own language. So it's coming directly, there's no change in it. I don't think it's an interpreter. You're just speaking another language.
The question would come is, are you providing them with anything that is in a written language outside of their native language?
Never.
So that's the thing. So if you're providing them with a contract and explaining to them what it says.
Oh God, no, I send them to a lawyer.
But I mean, it happens because realistically, you may not have that lease translated into Mandarin. So, we understand that may happen. So just we want to make sure that everyone's kind of acknowledging what role people have served in terms of, and I think it protects both the broker or the salesperson as well as the client.
I think you have to be clear in determining whether you are talking about someone who is translating compared to someone who is interpreting. Apparently, there were two different definitions. And it sounds like you're more likely interpreting than you are translating.
A translation is always an interpretation because languages are never truly equivalent.
No, but I believe there is a definition in law now as to who can be a translator, who can be an interpreter. So I think we should be just clear on our definition. If there's no difference, okay, but a friend of mine who does do that has often criticized me for using the wrong term, either, translator or interpreter.
It is my understanding that translation services are those of the written word, where interpreter services are those of the spoken word.
Okay.
And we consistently use in here interpretation or interpreter rather than translation. That is an interesting point, though, Commissioner Dunn.
Should you be covering both though? Because in some cases you'll be translating a contract. Right, because that's written.
But do contracts get translated, or does someone hire an interpreter
Interpreter
and sign
to
it?
verbally
Yeah.
go over the contract. Okay.
Because they're not going to sign a contract that's in Mandarin. Because I imagine the court system would have a hard time with that. I guess they could hire a translator.
But then, William Ravis then winds up translating that contract into Mandarin. Then that consumer, that lessee, actually has the advantage now, likely over the broker that doesn't know the plain language of the Mandarin contract. So
Do some residential agents, let's say, who work, with Spanish speaking people, do they offer contracts in Spanish and in other languages?
I don't believe we have contracts that we use in at least Hartford County and probably statewide that are in any other languages, because that's come up before that we potentially should offer them in other languages, and I don't believe they exist right now.
That's a shame.
okay.
That's not saying that there's not contracts going on from attorneys who have made these contracts, purchase and sales agreement in different languages.
But as long as it's in the language, the first language or the primary language of that consumer, that's what we care about. So, you know,
Yeah, if all of the transactions are happening in Spanish and the parties are speaking Spanish, none of this language would come into effect.
yeah.
Okay.
And then I think here, this was just a note someone had brought up a bit ago that related to for real estate licensees, what could be done in terms of like if you were leasing property. It is not for property managers of a property. It's only if you don't have to have the leasing agent or salesperson credential. If you're an on-site residential supervisor custodian, that means you live there. So it's essentially the same thing as an owner. This was someone had asked us about that, but so that's not a loophole for property managers. This is all just moving definitions up. Again, penalties went into the enforcement section. Moving definitions up in 329.0. And with 2 minutes to spare, I am going to be honest, I didn't know they were going to make it by 4. This is the end of the document as drafted that we sent out last time. Now, that being said, you know, we have talked about a number of things over the course of the last, you know, a few weeks over the course of this meeting and the last 2. And there was another conversation. I really appreciate the time of Chairperson Castleton and Commissioner Gray to meet with our staff about how to deal with brokers that may become incapacitated or that die during the course of running a business and how that gets transitioned. So we do have changes that we are proposing to this document. What we're going to do is clean up what we have, incorporate stuff from today, and then send out a red line draft to everyone for comments. Now that we kind of walk through this, give you some time to mull it over with that. And then, as I mentioned previously, our legislative package needs to go in by the end of the month. So like that is not a negotiable timeline. Like, that is when it has to go to the governor's office. And so we implore commission members as well as CTR to provide us with comments by the end of the month on any of these issues, because this is really the time where we can start incorporating things in. And we have to figure out also what the fiscal impact is on DCP or the industry of any of these changes. That all being said, you know, you guys have all worked with Paulette for a while. Ryan has become a familiar face now, as is Ben. I plan on being with you guys for a while, as you all know. Baby's coming soon. And
Congratulations.
I don't really think I'm going to make it to the end of the month. So if you get a bounce back, then, you know, Paulette, Ryan, and Ben are your team. They've got this. They will certainly carry this through the rest of the way. Obviously, Leslie is our legislative director who will be navigating this from submission through session. We're really here, mainly in the meantime, as the lawyers who are going to help craft the language. So yeah, bring your questions in, the earlier the better. And if I do not see you guys again virtually via, you know, Zoom or Teams, then I'll be back in the beginning of January and can't wait to see how this all turns out over our next legislative session.
Best wishes from mom and
Best
baby.
wishes. Yeah.
Thank
Good luck to
you.
Ann.
All right. Well, have a wonderful afternoon, everyone. We'll talk soon.
All right,
Bye-bye.
thank you.
Bye.
Adjourn the meeting.
Thank you.